Hey everybody, welcome back. Jeff Althaus for Althaus Law. I'm an estate planning and probate attorney, and today we're talking about guardianships. Now, we have to break this into two parts because guardianships not only apply to adults, but they also apply to minor children. I'll start with adults first. A guardianship for an adult is usually what happens if something goes wrong. What I mean by that is if you have a proper estate plan, you can avoid a guardianship for an adult completely, which is nice because guardianships are court hearings. So you're in front of a judge, and that judge is appointing a professional to manage your healthcare decisions. And this isn't a cheap hearing, and the judge is usually a stranger, and they're appointing another stranger to make your medical decisions for you. With a proper estate plan, you can have a medical power of attorney in place that you pick the person who's making these decisions for you. And then you don't have to have a stranger appointed who you have to pay, I don't know, maybe even $300 an hour, appointed by another stranger, the judge. So when you have a medical power of attorney, you don't need to go get a guardianship in most situations. And I should preface that if you're watching this in any state that's not Colorado, sometimes guardianship and conservatorship, which we'll have another video on, the terms are flipped around. But in Colorado, a guardian is a court-appointed medical power of attorney. And you go to a guardianship hearing. That hearing can be as expensive as $5,000 to $10,000. And then, like I said, you have to pay a professional an insane hourly rate to make these decisions for you. So it's much better to avoid the guardianship altogether. Make a plan in advance because then you don't have to pay any of those fees that I just talked about. Another downside to guardianships is that they're time consuming. And let's say a family member is appointed as guardian. They now have responsibilities with the court where they are legally obligated to file annual reports, sometimes different updates, depending on what they're trying to do with your medical health. And they may also have to request court approval for certain actions they want to take. And that's not fun. It can cause a lot of delays and just keep adding expenses. So guardianship for adults is a court hearing where they basically appoint a medical power of attorney to make decisions for your healthcare. Time consuming, expensive, don't want to go there. Keep in mind, in order to be in this, you have to be incapacitated. So they're not appointing guardians for people who are walking around perfectly healthy. You either have to be diagnosed as having Alzheimer's, dementia, or something else where a doctor has said you no longer have capacity to make decisions for yourself. So that's a pretty big point. You can't just get to a guardianship hearing on an everyday basis. That's guardianship for adults. Now we can talk about guardianship for minor children. The law is a little screwy. It treats incapacitated adults pretty much the same as minor children. Now, this is a little different because in your will, you can designate a guardian for your minor children. And what that says is, hey, if I can't be mom or dad for my children, who's going to do that? And that's whether the parent is incapacitated, just is out of town for a little while, or if they pass away. Then who steps into that role? That's what you name in your will for your minor children. Super helpful. I recommend that for everyone. That's because it makes the guardianship hearing much easier for minor children. We can never get out of the guardianship hearing for minor children if a parent passes away. Let's say both parents of a child pass away. A judge still wants to protect what they call the best interests of the child. So we have to have a guardianship hearing. But if you've named that guardian in your will, it makes that hearing a lot quicker. You get to pick who mom and dad are, and the judge basically just approves it. If you don't have a guardianship in place for minor children, the judge, who is a stranger, is appointing another stranger to be the parent for your children. And that's where foster care can come in. You don't know who's going to be caring for your child. It could be crazy Uncle Teddy that no one would want around your children at all. The judge just has to guess what's best for your children. So you name that guardian for your kids inside your will. That takes care of it. It doesn't stop the guardianship hearing, but it makes it much easier, much more effective, and you have said who you want that guardian to be. So to sum up, guardianship for minor children just says who is going to be mom, who is going to be dad for this minor child if the parents can't. And that's pretty much it for guardianship. You can have it for adults, you can have it for minors. You want to avoid it at all costs if you can, or at least make it as easy as possible. That's all I've got for that. Thanks for listening. Jeff Althaus with Althaus Law. Check us out again.